Hi everyone, welcome back to the channel. We're going to take a look at Article 13, European Union. Boy, is this going to be a rabbit hole. It's going to get deep. Okay, so let me state first foremost, I am not an attorney. I have never went to law school. I've read all portions of law books here and there, but no, I don't practice law. I'm not a practicing attorney. I'm not a lawyer, but I can follow a rabbit hole. So let's get started. And it begins. Article 13 plus related definition. So I'm going to be looking down because I'm reading this. I could read it on the screen, but it's easier for me to read this on the nice piece of paper that I've done, printed. Okay, online content sharing service provider means provider of an information society service whose main or one of the main purposes is to store and give public access to a large amount of copyright protected works or other protected subject matter uploaded by its users, which it organizes and promotes for profit making purposes. Providers such as not-for-profit online encyclopedias, not-for-profit educational and scientific repositories, open source software developing and sharing platforms, electronic communication service providers as defined in Directive 2018/1972. 2018/1972, establishing the European Communications Code, online marketplaces and business-to-business cloud services and cloud services which allow users to upload content for their own use shall not be considered online content sharing service providers within the meaning of this directive. So, based on what I believe they're saying here is, OneDrive from Microsoft and Google Drive from obviously Google are exempt. Let's see. Article 13. 1. Member states shall provide that an online content sharing service provider performs an act of communication to the public or an act of making available to the public for the purposes of this directive when it gives the public access to copyright protected works or other protected subject matter uploaded by its users. An online content sharing service provider shall therefore obtain an authorization from the rights holders referred to in Article 3, 1, and 2 of Directive 2001/29/EC, for instance by concluding a licensing agreement in order to communicate or make available to the public works or subject matter. So we have to go to, here, I'll bring this up here. We'll go to 2001/29 EC, and they want Article 3. So we have to find Article 3. Why don't we just search for Article 3? 3. Okay, Article 3. Right of communication to the public of works and right of making available to the public other subject matter. Member states shall provide authors with an exclusive right to authorize or prohibit any communication to the public of their works by wire or wireless means, including the making of available to the public of their works in such a way that members of the public may access them from a place and at a time individually chosen by them. Member states shall provide for the exclusive right to authorize or prohibit the making available to the public by wire or wireless means in such a way that members of the public may access them from a place and a time individually chosen by them for performers, fixations of their performances, phonogram producers of their phonograms, a old-time record. For the producers of the first fixations of films, of the original copies of their films. Okay, all right. And Directive 2. Well, yeah, I read both 1 and 2. Okay, so, all right, so basically what this means is they're allowed to, the copyright holder is allowed to license out their works. Couldn't I just said that? I mean, that's, again, I'm not a lawyer, but basically that's what it says to me. Section 2 out of Article 13. Member states shall provide that when an authorization has been obtained, including via a licensing agreement by the online content sharing service provider, this authorization shall also cover acts carried out by its users of the services falling within Article 3 of Directive 2001/29/EC. When they are not acting in a commercial basis or their activity does not generate significant revenues. Now, how do they define significant revenues? Somebody who makes $50,000 in New York may be the equivalent of making $20,000 here, in Ohio. So how do they come up with significant revenues? But let's take a look at 2001/29/EC Article 3. Oh, we just did. Yeah, we just did, I think. Yep. So let's refer back to that. Not acting, so they can obtain a license when they are not acting on a commercial basis or their activity does not generate significant revenue. Section 3. When an online content sharing service provider performs an act of communication to the public or in an act of making available to the public under the conditions established under this directive, the limitations of liability established in Article 14.1 of Directive 2000/31/EC shall not apply to the situations covered by this article. So, we go to 2000/31/EC. We go to 2000/31/EC. We go to Article 14.1. So let's look up. I guess Article 14. So let's okay, hosting. Okay, wherein information society service is provided that consists of the storage of information provided by the recipient of the service, member states shall ensure that the service provider is not liable for the information stored at the request of a recipient of the service, on condition that the provider does not have actual knowledge of the illegal activity or information and its regards claims for damages, is not aware of facts or circumstances from which the illegal activity or information is apparent, or the provider upon obtaining such knowledge or awareness acts expeditiously to remove or to disable access to the information. So basically this would be equivalent to the quote-unquote safe harbor provision for YouTube, Google, Bing, and everybody else. Okay. In other words, those protections from this article, Article 14, go away. This shall not page 2. Affect the possible application of Article 14.1 of our... Oh, here we go. Affect the possible application of Article 14.1 of Directive 2000/31/EC to those service providers for purposes falling outside of the scope of this directive. So they're not liable for something that this directive doesn't cover. Part 4. If no authorization is granted, online content sharing service providers shall be liable for unauthorized acts of communication to the public of copyright-protected works and other subject matter, unless the service providers demonstrate that they have A, made best efforts to obtain an authorization, and, not or, and, B, made a accordance with high industry standards of professional diligence best efforts to ensure the availability of specific works and other subject matter for which the right holders have provided the service providers with the relevant and necessary information, and in any event, C, acted expeditiously upon receiving a sufficiently substantiated notice by the copyright holders to remove from their websites or to disable access to the notified works and subject matters, and made best efforts to prevent their future uploads in accordance with paragraph B. So this sounds like the U.S. equivalent of the DMCA, except by the way this reads to me, and again, I'm not a lawyer or an attorney or anything like that, reads to me like once they're notified that me doing this, just holding up my hand and doing this gesture, that's somehow copywritten, which we know, in the U.S. you can't just do that and that's copywritten. But let's just say for the sake of this example, this is. Well, once I do this and it's copywritten, so somebody else goes on their YouTube channel or whatever, wherever, and they do that, I can file a claim that they're using my copywritten works, and once they're notified of it, then anybody that ever does this and uploads it, they're now, as long as it's allowed to be uploaded and allowed to be put on the public, and to the public for viewing, if they're allowed to do that, then they're liable. So that's safe. The first time, the safe harbor provision is intact if they didn't know. But once they are known about it, they have to prevent it from happening again. Future uploads in accordance with paragraph B. So once they're notified of it, if somebody else does the same thing, then guess what? Now, if the filter doesn't catch it, then they're liable because they were notified of it once. Somebody else did it. Now they're liable completely, unless they have a license. Okay. 4A. In determining whether the service has complied with this obligation under paragraph 4, and in the light of the principle of proportionality, the following should, among others, be taken into account. The type, A in parentheses, the type, the audience, and the size of the service and type of works or other subject matter uploaded by the users. Part B, the availability of suitable and effective means and their cost for service providers. 4AA. Member states shall provide that when new online content sharing service providers whose services have been available to the public in the Union for less than 3 years and which have an annual turnover below EUR 10 million within the meaning of the Commission Recommendation 2003/361/EC, the conditions applicable to them under the liability regime set out in paragraph 4 are limited to the compliance with the point A of paragraph 4 and to acting expeditiously upon receiving a sufficiently substantial notice to remove the notified works and subject matters from the website or to disable access to them. Where the average number of monthly unique visitors of those service providers exceeds 5 million, calculated on the basis of the last calendar year, they shall also demonstrate that they have made best efforts to prevent further uploads of the notified works and other subject matter for which the right holders have provided relevant and necessary information. So it kind of holds smaller, how it defines a smaller site is by 10 million euros, or they have less than 5 million members. You still have to comply, but it's a little bit looser in their regulation, not by much. Part 5. The cooperation between online content service providers and right holders shall not result in the prevention of the availability of works or other subject matter uploaded by users which do not infringe copyright and related rights, including where which works or subject matter are covered by the exemption or limitation. In other words, if it's if I'm doing a how-to video on how forks were invented, then I can reference copywritten material because educational was exempted. You know, and we should all know how to use a fork, but it's just for the, you know, just as an example. Member states shall ensure that users in all member states are able to rely on the following existing exceptions and limitations when uploading and making available content generated by users on online content sharing services. A. Quotation, criticism, review. B. Use for the purpose of caricature, parody, or there's a gentleman on he has a YouTube channel called Lawful Masses with Leonard French. Great content. He is a copyright attorney from what I understand in Pennsylvania. Pastiche is how that's pronounced, and yeah, just go look it up on YouTube. He had a hard time with that word too, and I don't know. He said what it meant. It's I believe the word is the word is like to mimic or to what's the word? Is the sincere imitation? So I believe it was imitation is what pastiche means. Okay, part 7. The application of the provisions in this article shall not lead to any general monitoring obligation as defined in Article 15 of Directive 2000/31/EC. So let's take a look at this. Let's see. So 2000, is that this that we have up already? 2031/EC. Okay, so we want Article 15 now. All right. No general obligation to monitor. Well, which is that's where they're referencing like a filter. Okay, no obligation to monitor, but that's the AI filter. Um, and you just said earlier that if it gets uploaded again and they knew that the work was already copywritten because they had a notice from someone else, and somebody else uploads something, where it violates it, then their safe harbor provision goes away. But they don't have to use a filter. That's what that is. Okay, so member states shall provide that online content sharing service providers shall provide rights holders at their request and with adequate information on the functioning of their practices with regard to the cooperation referred to in paragraph 4, which we went over, where license agreements are concluded between service providers and rights holders, information on the use of content covered by the agreements. This is not a rabbit hole that I'm really enjoying going down because it's not getting better. Member states shall provide that an online sharing service provider puts in place an effective and expeditious complaint and redress mechanism that is available to users of the service in case of disputes over the removal or blocking access to works or other subject matter uploaded by them. That sounds like the community strike that YouTube implemented. Again, I'm not an attorney. When right holders request to remove or disable access to their specific works or other subject matter, they shall duly justify the reasons for their request. Complaints submitted under this mechanism shall be processed without undue delay, and the discussions to remove or disable access to uploaded content shall be subject to human review. Oh, how many people do you have to employ to be able? YouTube gets hundreds of videos, probably every minute, because they're not just in the U.S., they're basically all over the world. How many people can YouTube afford to employ to do this? And then without undue delay. If you have 5 people that do this and you have 100 requests a day, okay, how are 5 people going to review 100 videos in a day? They're not. Next paragraph. Member states shall also ensure that out-of-court redress mechanisms are available for the settlement of disputes. Such mechanisms shall enable disputes to be settled impartially and shall not deprive the user of the legal protection offered by natural law, without prejudice to the rights of users to the recourse to efficient judicial remedies. In particular, member states shall ensure that users have access to a court in order to court or other relevant judicial authority to assert the use of the exception or limitation to copyright rules. So you can dispute it in a court, which you can do here. This directive shall in no way affect legitimate uses, such as uses under exceptions and limitations provided for in union law, and shall not lead to any identification of individual users or to the proceeding of their personal data, in accordance with Directive 95/46/EC, Directive 2002/58/EC, and the General Data Protection Regulation. They have the right to remain private. Online content sharing service providers shall inform the users in their terms and conditions about the possibility of them to use works that other subject matter under exceptions or limitations to copyright and related rights provided for in union law. This is only page 3. Section 9. As of date. It hasn't been confirmed yet, so. The Commission, in cooperation with the member states, shall organize stakeholder dialogues to discuss best practices for the cooperation between the online content sharing service providers and right holders. The Commission shall, in consultation with online content sharing service providers, right holders, users associations, and other relevant stakeholders, and taking into account results of the stakeholder dialogues, issue guidance on the application of Article 13, in particular to regarding cooperation referred to in paragraph 4. When discussing the best practices, special account shall be taken, among others, of the need to balance fundamental rights and the use of exceptions and limitations. For the purposes of its stakeholders' dialogue, users associations shall have access to adequate information from online content sharing service providers on the functioning of their practices with regard to in paragraph 4. Wow. No wonder everybody is up in arms over this. Over the last years, the functioning of the online content market has gained in complexity. Online content sharing services providing access to a large amount of copyright-protected content uploaded by their users have become main sources of access to content online. Online services are means of providing wider access to cultural and creative works, and offer great opportunities for cultural and creative industries to develop new business models. However, although they allow for diversity and ease of access to content, they also generate challenges when copyright-protected content is uploaded without prior authorization from rights holders. Legal uncertainty exists as to whether such services engage in copyright relevant acts and need to obtain authorizations from rights holders for the content uploaded by their users who do not hold the relevant rights on the uploaded content, without prejudice to the application of exceptions and limitations provided for in union law. This uncertainly affects rights holders' possibilities to determine whether and under which conditions their works and other subject matter are used, as well as their possibilities to get an appropriate I know how to pronounce this word, but I'm not going to remuneration. In other words, they get paid for it. It is therefore important to foster the development of the licensing market between rights holders and online content sharing service holders. These licensing agents should be fair and keep a reasonable balance for both parties. Rights holders should receive an appropriate reward for the use of their works or other subject matter. However, it is contractual freedom is not affected by the provisions. The rights holder should not be obligated to give an authorization or to conclude licensing agreements. In other words, just because they started talks doesn't mean they're obligated to complete it. And so they don't have to give their permission to have their work be freely accessible. But this just reads to me, and I could be wrong, and again, I'm not an attorney, that if you don't have, this to me, the way this reads, is essentially Google in Europe and its member states should just pull their plug. No, okay, fine, bye. Because you have to go to everybody, and no matter what the works is, and get a licensing agreement so that people can upload certain things in there to their YouTube channels, because it's the safe harbor provision that they're given is so easily snapped away. As a business, where you're liable, which is what this is saying, for what people upload, it's done once, you're notified, you take it down, somebody uploads the same thing, and the filter, let's face it, they're going to have to filter it. Somebody uploads the same thing or similar thing that infringes on the copyright holders, and they don't have a license for. Now their safe harbor provision goes away, and they're liable. 37A, certain information society services as a part of normal use are designed to give access to the public to copyright-protected content or other subject matter uploaded by their user. The definition of an online content sharing service under directive should target only online services which play an important role in the online content market by competing with other online content services, such as online audio and video streaming services, for the same audiences. The services covered by this directive are these services, the main or one of the main purposes of which is to store and enable users to upload and share a large amount of copyright-protected content for the purposes of obtaining profit therefrom, either directly or indirectly by organizing it and promoting it in order to attract a larger audience, including by categorizing it and using targeted promotion within it. The definition does not include services which have other main purposes than enabling users to upload and share a large amount of copy-protected content with the purpose of obtaining profit from this activity. These include, for instance, electronic communication services among the meaning of Directive 2018/1972, and that's the establishment, I did kind of read it, of the European Electronic Communications Code, as well as providers of business-to-business cloud services and cloud services which allow users to upload content for their own use, such as cyber lockers or online marketplaces whose main activity is online retail and not giving access to copy-protected content. Providers of services such as open source software development and sharing platforms, not-for-profit, scientific, and they're covered again. So they get their safe harbor. But commercial services don't, like YouTube. Finally, and this is not finally, but in this section, finally, in order to ensure a high level of copyright protection, the liability exception mechanism provided for in Article 13 should not apply to service providers, the main purpose of which is to engage in or to facilitate copyright privacy or piracy. So yeah. Now, 37B. The assessment of whether an online content sharing service provider stores and gives access to a large amount of copyright protected content needs to be made on a case-by-case basis and take account of the combination of elements such as audience of the service and the number of files of copyright protected content uploaded by the users of the services. Okay, that's a bit confusing. Assessment of whether online content sharing stores, of course, YouTube stores a lot of copy protected content but they, as being a YouTube video creator, I own the copyright to what I'm doing now, or what you're seeing. If somebody downloads this and re-uploads it, then they're in violation of my copyright, because this is not copywritten, and this is actually still a draft. Yep, the unofficial. But it's what they're proposing. I'm not entirely sure what it says there. Maybe somebody who's an actual attorney might be able to explain that. Please put that in the comments down below. Paragraph 38, onward and upward. This directive clarifies that online content sharing service providers engage in an act of communication to the public or making available to the public that they give the public access to copyright protected works or other protected subject matter uploaded by their users. Consequently, the online content sharing service providers should obtain an authorization, including via a license agreement, from the relevant right holders. This does not affect the concept of communication to the public or of the making available to the public elsewhere under union law, nor does it affect the possible application of Article 3.1 and 2 of Directive 2001/29/EC. We looked at that. To other service providers using copy-protected content, including to the micro and small enterprises or other service providers which are excluded from the scope of this directive. I think we all know what that reads. In other words, get a license. When online content sharing service providers are liable for acts of communication to the public or making available to the public under the conditions established under this directive, Article 14.1 of Directive 2000/31/EC should not apply to the liability arising from Article 13 of this directive. This should not affect the application of Article 14.1 of Directive 2000/31/EC to these service providers for purposes falling outside the scope of its directive. Let's see, so what do we see here? 2031/EC. That is this page, and I think we did look at it. Which article? Article 14. That's where the providing this. That's this section here. Article 14. Posting. Okay. That's where they don't have. This is saying if they have knowledge, then whatever. Let's see. In particular, the specific regime applicable to the new online content sharing service providers with an annual turnover of below 10 million euros, whose average number of monthly unique visitors in the Union does not exceed 5 million, should not affect the availability of remedies under national and EU law. In other words, they're subject to the same. They're subject to this too. Now, I'm going to have to start reading online, and it's not blacked out. It's that it's highlighted. Well, I only have a black and white printer, so I don't have a color printer. It's toner. So this is what it does when you highlight something, is it nearly blacks it out. So we're going to revert to an online version. Okay, so here's the version that my printer couldn't handle. Had to black it out. There is no authorization has been granted to the services providers. They should make their best efforts in accordance with high industry standards of professional diligence to avoid the availability on their services of unauthorized works and other subject matter as identified by the relevant rights holders. For that purpose, rights holders should provide the service providers with necessary and relevant information, taking into account, among other factors, the size of rights holders and the type of their works and other subject matter. The steps taken by the online content sharing service providers in cooperation with rights holders should not lead to the prevention of the availability of non-infringing content, including the use of works or other protected subject matter covered by a licensing agreement, exception, or limitation to copyright. Thereby, it should not affect users who are using the online content sharing providers' services in order to lawfully upload and access information on these services. So, like what I'm doing, it's legal. This is a publicly available document, and I'm commenting on it. It's fair use, but this is not a copywritten work. This is a draft of a law, so it's not a copywritten work. I'm reading it and giving it, be all my opinion by, how I'm interpreting this. And again, I'm not an attorney or anything like that, but so far it's like they handed, went to the United States, said, "Hold my beer" on this copyright thing. It gives a lot of authority to rights holders, very little, no recourse for online services. And that's probably why we're seeing a lot of what we're seeing in the United States with YouTube, with the increasing restrictions because of stuff like this. The obligations established in Article 13 should also not lead to member states imposing a general monitoring obligation. So how are they supposed to not have it? How are you not supposed to have a monitoring obligation? You said in earlier paragraph or earlier part of this Article 13, if you're notified about a violation of your copyright, if you notify blah, blah, blah about it, they take down that video. If it's uploaded again, now you could go after them. that safe harbor provision is gone because you've already notified them once that, hey, this is infringing. So they take it down. Now somebody else uploads it. Now they have no safe harbor because they've already been notified once. They already had the information. So how do they not have an obligation to monitor? When assessing whether an online content sharing service provider has made its best efforts according to the high industry standards of professional diligence, account should be taken of whether the service provider has taken all of the steps that would be taken by a diligent operator to achieve the result of preventing the availability of unauthorized works or other subject matter on its site, taking into account best industry practices and the effectiveness of the steps taken in light of all relevant factors and developments, as well as the principle of proportionality. For the purposes of its assessment, a number of elements should be considered, such as the size of the service, the evolving state of the art of existing means, including future developments. For avoiding the availability of different types of content and their costs of the services, different means to avoid the availability of unauthorized copyright protected content may be appropriate and proportionate per type of content, and it is therefore not excluded that in some cases unauthorized content may only be avoided upon notification of rights holders. Many steps taken by the service providers should be effective with regard to the objectives sought, but should not go beyond what is necessary to achieve the objective of avoiding and discontinuing the availability of unauthorized works and other subject matter. Any steps taken by the service providers should be effective with regard to the objectives sought, but should not go beyond what is necessary to achieve the objective of avoiding and discontinuing the availability of unauthorized. Wow. And I thought we had it bad with legislators. Wow. But don't go beyond this. But if you don't, high industry standards of professional diligence and best practices and best efforts. And if unauthorized works and other subject matter become available despite the best efforts made in cooperation with rights holders as required by this directive, the online content sharing service providers should be liable in relation to the specific works and their subject matter for which they have received the relevant and necessary information from rights holders. This paragraph just contradicted all of this. Unless they demonstrate that they have made their best efforts pursuant to high industry standards and professional diligence. filters. In addition, where specific unauthorized works or other subject matter have become available on the services, including irrespective of whether the best efforts were made and regardless of whether rights holders have made available the necessary information in advance, the online content sharing service providers should be liable for unauthorized acts of communication to the public of works and other subject matter. Does this kind of not say to you? It kind of does to me. I could be wrong, but I'm kind of interpreting this to say that if you think it's copyrighted work and you host it on your site and it turns out it is a copywritten work, you're liable. Your safe harbor goes away. But you weren't sure if it was. You didn't know for certain it was, but you think it might have been. And upon receiving a sufficiently substantiated notice, they fail to act expeditiously to remove from their websites or disable access to the notified works and subject matter. Additionally, these services should also be liable if they fail to demonstrate that they have made their best efforts to preserve the future uploads. But you don't have to put in a filter. You don't have to monitor everything of specific unauthorized works based on irrelevant and necessary information provided by the rights holders for that purpose. This law is just full of contradictions. On one hand, it says, once you're notified, if it pops up again, you're liable. That's the way I'm reading all this. Okay? You've been notified once. It shows up again, you're liable. But you don't have to. But as a service, service provider, you don't have to monitor everything. How don't you? Wouldn't that be high industry standards and best practices? Wow. Okay, so from here. When right holders do not provide the service providers with the necessary and relevant information on the specific works, this section here, I'm sorry, I read ahead, but this section here just means and says if you don't provide the complete information, then they can't do their job, so they're not liable. So if you just say, I have the copyright to do that, you need other documentation and that stuff. Let's see now. This is, I'm sure, highlighted for a reason, and it probably is. My best guess is it probably contradicts something else. So 38 BA, Article 13 for AA, applies to new online services. A similar provision is unforeseen in Article 16.2 of Directive 2014-26 EU of 26 February 2014 on collective management of copyright and related rights and multi-territorial licensing of rights in music works for online use in the internal market. The rules set in this directive are intended to take into account the specific case of startup companies working with user uploads to develop new business models. The modified regime applicable to new service providers with a small turnover and audience should benefit genuine new enterprises and should therefore cease to apply 3 years after they become first available online in the Union. It should not be abused by arrangements aiming to extend the benefit of its modified regime beyond the first 3 years. In particular, it should not apply to services newly created or to services provided under a new name, but which are pursuing the activity of an already existing online content sharing service provider which could not or does not longer benefit from its regime. So you just can't change your name. You kind of get a little bit of protection for the first 3 years. That also doesn't mean you get to abuse this privilege. And you just can't, once you hit the 3-year mark, you just can't change your name and just continue where you left off. The online content sharing service provider should be transparent towards the rights holders with regard to the steps taken and the contents of the cooperation. As different actions may be undertaken by the online content sharing service providers, they should provide rights holders at their request with adequate information on the type of actions undertaken and the way they have implemented what they are implemented. Such information should be significantly specific to provide enough transparency to rights holders without prejudice to the business secrets of online content sharing service providers. Service providers should, however, not be required to provide rights holders with detailed and individualized information for each work and other subject matter identified. This is without prejudice to contractual arrangements, which may contain more specific provisions on the information to be provided where agreements are concluded between service providers and rights holders. In other words, the right holders can ask for, hey, what did you do about this? Oh, well, we took the video down and that was it. We applied your content to our filter, our monitoring system, which we're not under obligation to have. 38B, the online content sharing service providers obtain authorizations, including via licensing agreements for the use on the service of content uploaded by the users of the service. This should also cover the copyright relevant acts in respect of uploads by the users within the scope of the authorized grant to the service providers, but only in cases where the users act for non-commercial purposes, such as sharing their content without any profit-making purpose, or when the revenue generated by their uploads are not significant in relation to the copyright relevant act of the users for which they are covered. In other words, you can upload a trailer, but you're not allowed to make money on it as long as the service has a license agreement with them. When rights holders have explicitly authorized users to upload and make available works or other subject matter on an online content sharing service, the act of communication to the public of the service is authorized within the scope of the authorization granted by the right holder. However, there should be no presumption in favor of the online content sharing service providers that their users have cleared all the relevant rights. I think you understand what that means. 39A, the steps taken by the online content sharing service provider should be without prejudice in the application of exemptions and limitations to copyright, including in particular those which guarantee the freedom of expressions of users. Users should be allowed to upload and make available content generated by users for specific purposes of quotation, criticism, review, satire, parody, or there's that word again. Yeah, that word. This is particularly important to strike a balance between fundamental rights and the character of fundamental rights of the European Union, in particular the freedom of expression and the freedom of the arts, and the right to property, including intellectual property. For these reasons, these exceptions should be mandatory in order to ensure that users receive uniform protection across the Union. It is important to ensure that online content sharing services operate an effective, compliant, and redress mechanism to support these users. In other words, they can have a right to appeal. 39B, as soon as possible after the entry into force of this directive, the Commission, in collaboration with member states, should organize dialogues between stakeholders to arrive to a uniform application of the obligation of the cooperation and to define best practices with regard to the appropriate industry standards of professional diligence. For these purposes, the Commission should consult relevant stakeholders, including user organizations and technology providers, and take into account the developments on the market. User organizations should also have access to information on actions carried out by online content sharing service providers to manage content online. This is the EU's, like I say, this is everything I've written. It's in this document that we've gone over. I've thrown in how it reads to me. Maybe I'm wrong, but this is how I'm reading it. Again, for the last time, I'm not an attorney. This is not legal advice, but it just strikes me as, the United States come up with that horrible DMCA in the 90s, and this is the European version of saying, hey, United States, hold my beer. How can YouTube or anybody, even a new startup, I mean, they get some protections, but not a ton, comply with this? Basically, it's, to me, the way this reads is if you're in the EU and you have a YouTube account, whatever, what it is probably called youtube.eu. I don't know. It might be. I'm not sure. I do see some British people on the .com, but I digress. It seems to me that the way YouTube should handle this is no streaming, period, because you can't take a chance. 2, you upload your content and we'll review it. And if we find anything, then we're not putting it on. Or 3, just get rid of all the users, just have viewers, and the only people you trust is corporate. Big pockets, corporate, because they can afford to pay if they screw up. If you want to continue to use our platform, we're going to levy this fine against you because you cost us, millions of dollars because we had to go to court because you uploaded something stupid, even though we were notified and it got through our filter system. Because make no mistake, even though they said, well, you don't have to monitor, well, how else do you comply with this law? Unless you go to a system that says no streaming, no users uploading anything, because there's no way they could take the risk that you're going to upload something that has some sort of copywritten content. So let me know what you think. Tell me in the comments down below. A friend of mine and I do a YouTube show every Thursday at 7:30 Eastern Standard Time, called Anything Goes with George and Jonathan. Tune into that. Hit like, subscribe if you like this video. Come watch our show if you like to follow us a little bit. We're working on a website. It is called anythinggoes.com. We're working on that, and we'll see you guys. Hopefully there won't be a next time. Not with this anyway.